I'm Ravi Chandrapala, the founder of Armchair Criminal. This is a knowledge sharing platform, and I welcome you all to this program. It is said that law is order and good law is good order by Aristotle. That is how important it is. This is a program on hearsay evidence in the light of the Criminal Justice Act 2003. There are several parts to this program. This part of the program is the introduction to hearsay, and other parts will consider specific issues pertaining to hearsay. It is worth remembering that some parts of this program runs to several minutes with many slides to cover the areas in a comprehensive manner. The object is to provide good working knowledge and prepare those who are to sit for any examination and for those who are trying to understand the topic. Whilst this part of the program is called the introduction, there are very many important concepts to understand as the foundation for hearsay evidence. The technique that I have employed in this program is questions and answers. What I discuss here is my understanding and the interpretation of the law. And I would recommend that you do the same. There is no substitute for your own reading, but I recognize that some of us may find it beneficial to watch a video clip. There are several books that are available, and I would really recommend Hearsay Evidence by Professor J. Spencer of Cambridge University and the Blackstone's Practitioner's Book. So let's try to understand in layman terms, what is hearsay? I would describe it as gossip, tittle-tattle, when a witness is called to give evidence to any fact or opinion on a matter that he or she has no personal knowledge or first-hand experience of witnessing that. It is that type of evidence that is controlled through hearsay evidence. Let's consider, where do you find the applicable law for the English jurisdiction? The current rules of hearsay are to be found in Chapter 2, Part 11 of the Criminal Justice Act 2003. Please remember, unless I specify a specific act, I am referring to Criminal Justice Act 2003. What is the statutory definition of hearsay? You need to look at section 114, subsection 1, which reads as follows. In criminal proceedings, a statement not made in oral evidence in the proceedings is admissible as evidence of any matter stated, if but only if. That's a bit of a mouthful. And I have highlighted the relevant parts in red bracket squares because to highlight the importance of it. So first, let's look at what is criminal proceedings. The answer that you would find is in section 134. It defines criminal proceedings means criminal proceedings in relation to which the strict rules of evidence apply. Therefore, what this section does is to define the scope of the applicable rules, which goes on to basically describe criminal proceedings are the ones that strict rules of evidence apply, which means trials, fitness to plead hearings, Newton hearings. Just because certain matters are in court, it doesn't necessarily mean they are criminal proceedings within the definition of this act. For example, if you were to take poker proceedings, proceeds of crime, confiscation proceedings I'm talking about, that is not within the definition of hearsay, because very often you do get vast amount of hearsay evidence being allowed to go in for practical reasons there. Extradition proceedings. Extradition proceedings will come to a halt if the strict rules of evidence are applied with regard to hearsay. Because end of the day, what we are being asked to consider is a request from another country concerning a person who is in this country to be extradited to that country. So we have to assume what we are being told by the requesting country, the proceedings taking place in that country is perfect. Otherwise, the whole thing comes to an end. Then issues of bail and breaches of bail. In my opinion, again, that is for expedience. Can you imagine every time a person gets arrested for breach of bail, if the police officers, those who monitor tax curfews, monitoring companies having to come to court to give evidence, the whole thing will come to a grinding standstill. So what they have done is to take that part of the proceedings out of the definition. Equally, if you were to look at preventative orders, for example, restraint orders, criminal behavior orders, what we used to call ASBOs, they are based on intelligence, officers not necessarily coming to give evidence, or the officer who comes to give evidence is actually being told by someone else of the intelligence that they have on the person, and the like. If you are interested to consider authorities with regard to fitness to plead, you may want to consider Crown and Kyle, CHALL, 2007, EWCA 2647, and Gandhi for with regard to Newton hearings, 1989 authority. Next, let's look at what is a statement and a matter stated means. For that, you would have to consider section 115. And section 115 reads as follows. In this chapter, reference to a statement or to a matter stated are to be read as follows. Subsection 2. A statement is any representation, emphasize any representation, of fact or opinion made by a person, again, a person, important, whatever means, and it includes a representation made in sketch, photo fit, or other pictorial form. I'll explain this in a minute. A matter stated in one which this is one which this chapter applies, and if only if the purpose or one of the purposes of the person making the statement appears to the court to have been A, to cause another to believe the matter, or to cause another to act, or a machine to operate on the basis of the matter stated. Before we go any further, let me stop for a moment and look at one particular word, the purpose. If the purpose is to prove a consistent statement and not to prove to the truth of its content, then the purpose is to adduce that piece of hearsay evidence to prove a matter stated. All what is done is being to show consistency. I have said this before. In other words, say for instance, if a person is at a police station and he makes a no comment in the interview, the prosecution says, you invented this story for the first time in court. That person says, hold on, mate. No. That is not how it went. I told my solicitor at the police station. Forget about whether it's true or not. So what the purpose of adducing that previous statement is to show that it was said earlier. That is why I very often think those who do police station work should take a full proof of instructions, especially if the client is giving a prepared statement or giving a no comment interview. It may not be able to absorb the whole problem of an adverse inference being drawn, but what it might do is to rebut an allegation of recent fabrication. So it's quite important. Next is to cause another to believe, which is subsection 3A. If the Crown is making an application to adduce bad character, for example, if they are relying on the list of previous conviction from the PNC, what they are really doing there is adducing hearsay evidence, because it could not have been the case. The officer in court, the OIC, is actually the one who put the information onto the PNC in the first place. It would have been done by someone else. But that evidence is adduced to cause another person to believe. In other words, the prosecution is adducing bad character to show, say, propensity based on hearsay evidence. I will look at other important concepts that are in red brackets in a short while. Before we do that, I'm going to refer to certain cases at this stage, although here I will not consider each and every authority, but it is important to be aware of these authorities. Namely, the question is, what is the reason for this change in the law? The answer is to give a narrow definition with wider exceptions. When you look at the cases of DPP and Curley, Crown and Mayers, Singh, Leonard, Christomu, and Twist, will demonstrate the difficulties the courts experienced. And sometimes the Court of Appeal has been quite critical and unable to remedy the problems. So the law had to be changed. Now, what is the effect of hearsay evidence? The effect is hearsay evidence is subject to an exclusionary rule. If the matter stated is hearsay, then the court cannot receive that evidence unless one of the exceptions to the rule apply. And even when they do, the courts have to be very careful, be cautious of them. Where is the exclusion rule? Again, you go back to section 114. The operative words here are within the red brackets, but only if. Section 114, subsection 1, admissible as evidence, ... but only if. Then lists number of exceptions. A, any provision of this chapter or any other statutory provision makes it admissible. What it means is this particular act could give room for admitting hearsay evidence or certain other statutes. That is why I said earlier, unless I refer to specific act, I'm referring to this act, because there are other acts of parliament which allows to admit hearsay evidence. B, any rule of law preserved by section 118 makes it admissible. When we will look at this section later, it is the exceptions to the hearsay rule by virtue of preserved common law rules. Then C, all parties to the proceedings agree to it being admissible. If all the parties agree, what's the problem? The judge is not going to interfere. You all know your case. You all have agreed. Who am I to intervene? You're done with it. The next one is D. The court is satisfied that it is in the interest of justice for it to be admissible. That's a huge concept, huge concept. Before we proceed any further, it is worth mentioning, it is the party who is seeking to admit hearsay evidence has to make the application to overcome the exclusion rule. They bear the burden. It is important to equally understand why the parliament decided to bring in the 2003 Act, why hearsay is subject to as an exclusion rule. First, right to confront. We have an adversarial system here, and as such, the defendants have the right to confront their accuser. Therefore, they have the right to examine or have that witness examined by his or her advocate. Then the next concept is the right to a fair trial. How on earth can you have a fair trial based on hearsay evidence? The actual witness who has first-hand experience, if that person is not in court, how can you challenge? All what we have then in court is a mouthpiece reiterating what he or she has heard from someone else. How can you cross-examine? That's ridiculous. The other thing is the arbitrariness. No party can be sure just because they make an application that the hearsay will be allowed. And finally, one has to remember there are a lot of dangers in admitting hearsay evidence. That is why hearsay is subject to automatic rules of exclusion, unless the exceptions apply. The dangers, basically, there are several dangers. One is, if the witness is not in court to give evidence, but what that witness has said is being repeated in court, what you are hearing is piece of material, that which is not given under oath. That's the first issue. That witness not being in court, which we looked at earlier, the defendant cannot confront. Not only the defendant, any party can. No party can confront that witness and cross-examine. Equally, it is very important the tribunal of facts, be it the jury or the justices or the district judge in the magistrate's court, being able to see the witness and assess the demeanor. Sometimes the body language is more powerful than the words. It is important to see the demeanor of the person. And it is also thought that hearsay evidence is not the best evidence. However, at times, that argument is a little weaker in the eyes of the law right now. When hearsay evidence is admitted, especially lay members of a tribunal of fact, like the jury, or even for that matter, sometimes it could even happen with the justices, but less likely, could be misled as to the value and everything else around the piece of hearsay evidence. Why is it necessary to have the exceptions to this exclusion rule? Now, this is a novel concept for most of us who began our career before the criminal procedure rules came. And now it's expressly said the overriding object of the courts trying a criminal case is to establish the truth, adduce cogent evidence, and to allow the witnesses unavailable or that unbiased documentary evidence to be admitted in certain circumstances, the right to object to hearsay evidence, save witnesses time and court time, Therefore, the concept of not the best evidence is no longer a real argument, as I said earlier. Where there is now a lot of technology is available, that where one can bring evidence without the witnesses being in court. We looked at the opportunity to cross-examine. Remember that if the witness is not in court giving evidence, it denies the opportunity to expose the witnesses' inaccuracies in their evidence, and even to prove that they are lying, which could come not only from the actual evidence given in court, by looking at the demeanor of the person. It is equally important to note that the overriding objective of the criminal procedure rules is to acquit the innocent, convict the guilty. So it is in that spirit that hearsay evidence is looked at now. It's very important these days to look at the oral objective of the criminal proceedings whilst applying certain safeguards. So to conclude, I would say this. You can see that Criminal Justice Act 2003 was introduced to have a complete overhaul of the hearsay rules. There are several important issues to be considered, and one cannot be too careful with various concepts, which we will consider as this program develops into other parts. And in the absence of sound knowledge, one can easily allow hearsay evidence to be adduced. Therefore, a closer examination of these concepts cannot be overestimated. Whilst I say that, I again remind you considering and studying this subject, or for that matter, any other subject, is important. I would encourage you to do that. I hope you have found this part of the program has been helpful and you enjoyed it. I hope that you will join me in other programs. Thank you for watching. God bless.